Let's now quickly touch on this business-related story where we understand that a high court in the United Kingdom has ordered Process and Industrial Development Limited, that's P&ID, to pay Nigeria £20 million in damages and compensation within the next 28 days. The order followed the victory of Nigeria in an appeal against the $11 billion arbitration award in October 2023. The Business and Property Court of England and Wales, London, had in a judgment delivered on October 23 by Justice Robin Knowles, quashed an arbitration order on Nigeria to pay a total of $6.6 billion as damages accruing from March 2013, with interest at a rate of 7%, which amounts to $11 billion in 2017. The court had held that the award to P&ID was fraudulent and violated the Arbitration Act of 1996. Following the judgment, P&ID had attempted to revive their claims through fresh arbitration. Ruling on the motion for permission to seek a fresh arbitration, the court held that a fresh arbitration could not proceed while the 2023 judgment remained valid. To further discuss this development, Kenneth Ikenwa, a business, political and social policy analyst, joins me on the news. Kenneth, thank you so much for talking to us.
Yes, it's nice to be back on News Central. Thanks for having me on.
Now, the P&ID judgment handed down in favor of Nigeria found that the award had been obtained by fraud and in a way which was contrary to public policy. What do you make of the revelations surrounding the contract award and the court case?
All right, P&ID is becoming quite a popular lexicon in our business and public administration lexicon in Nigeria, becoming a big word. Good developments for Nigeria because it is a pointer to the direction of where we have been going as a country and a path that we need to retract our steps from. It's not also too good to see that Nigerian officials ab initio were involved in this scandal. But one of the two sides of the judgment that I have spoken about right on this wonderful channel of yours is that it helps to save Nigeria a lot of money, but yet coming back home, it doesn't address the issues of actually dealing with the perpetrators that were, fingered in the bribery and scandalous act of allowing this contract to even see the light of the day in the first place. So we need to turn the searchlight back on our civil service, on our country, on our institutions, and bring the perpetrators of this dastardly act that has also indirectly damaged the image of Nigeria, to book and, put them behind the bars if possible.
All right, so would this have been a meaningful deal for both parties at that time? Because our school of thought even believes that the deal was fraught with fictitious claims. Would there have been any benefits if they had both followed through with the agreement of that particular deal?
It's impossible to say that anybody that comes through the back door to want to do something for a country, for a company, or for an individual would actually have any good intentions or have a beautiful landing at the end of that engagement or that story. Simply put, if you actually had, as a company, as a firm, a good intention for a country, and you felt the best way to go about that was to go through the back door, there is no way that will have been of immense benefit to both parties, as the case is not unfolding. This is, for instance, one of the reasons why you see that there are so many abandoned projects in Nigeria today. Because when these projects were initially, commenced, they were commenced with a lot of, the contracts were obtained with a lot of bribery, a lot of scandal, a lot of, kickbacks, and so many things, so many adjectives that should not even be mentioned on television. So there is no way that somebody will have come to Nigeria or come to Africa to get something through the back door, through bribery, through corruption, and hope to have given you a quality output at the end of the day. That is why we see buildings collapsing in Nigeria. That is why we see infrastructure not lasting beyond the initially identified lifespan and much more. So things like this are big pointers to why we're not developing as a nation and why our infrastructure doesn't seem to be lasting for the purpose for which they were ab initio incurred and implanted on Nigerian soil. there's no way it will have been of benefit to anybody.
So let me now tie your response to what Mark Howard Casey, who is the lead counsel for Nigeria, what he said. He said P&ID was exactly the type of entity that was prepared to engage in bribery, and that corroborates what you just said. Now, I'm wanting to actually know, is this actually a common stance with companies who seek contractual agreements with the federal government through the back door in the bid of defrauding the country? Because, of course, you would want to look at issues like this and contractual agreements that have been signed with various contractors, with various companies, with government representatives being the ones to negotiate these terms on behalf of government. So should we now be looking at issues like this in the light or in the view of having to cross-check or investigate every single contract that has been signed on behalf of governments, looking at the past administrations up till now, to know which one actually favors Nigeria and the ones that are actually out or set to defraud the country?
I actually wish I could plead a constitutional protection to abstain from answering that question. But that would be an injustice to my own future and to the future of unborn Nigerians. So your question actually has two parts. The first part is whether this is usually the culture with multinational companies and foreign companies coming into Nigeria, not just Nigeria, into Africa. Well, the truth must be said, yes. This, to a great extent, is how many multinational companies, many transnational companies seek to entrench their operations in different, countries across the third world, not just in Africa, Latin America, and, in Asia. This is usually the case. But the issue with Nigeria seems to be becoming a culture. It's like a culture in our social system structure and milieu, which is a cancer that is definitely detrimental to the growth of the economy and to the development of the Nigerian social polity and state. What should we do? Well, I think you got it right on spot. We should go back, not just to the Fourth Republic, not even to the Second Republic. We should go back possibly to 1976 or 1975, where contracts were awarded for telecommunications in the telecommunications sector in Nigeria. You remember the ITT case, and Fela sang a lot about this. We should go back and start investigating those contracts, because they have cost Nigeria so much more than Nigeria has even lost from the theft of oil since 1966. So I couldn't agree with you any less. There should be a failed contracts tribunal as a separate institution existing away from EFCC, from ICPC, and the tribunal should be there, just as we have for elections, to investigate all contracts that have been awarded in Nigeria since 1960, which have failed to materialize any meaningful benefit for the Nigerian peoples and for the Nigerian state.
Thank you so much, Kenneth Ikenwa, for talking to us. It was nice having the discussion with you.
Thanks for having me on.